Major breaking news. We had oral argument today en banc in front of the Ninth Circuit Court of Appeals out there in San Francisco, California, in the Duncan versus Bonta case, which deals with California's ban on magazines that hold more than 10 rounds. A crazy case. We're going to lose this because it's a terrible anti-gun Ninth Circuit, but I'm going to break down the arguments that California raised, some of the ways that we can improve, and what we need to do to get to the U.S. Supreme Court, where we will win if we can get a magazine or AR-15 case to the Supreme Court. But we're not there yet. Let's break it all down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many books, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. Another book coming out very soon. Wait for the announcement. All right, folks, today we had an oral argument in Duncan versus Bonta, which is the California magazine ban. And if you follow the Four Boxes Diner, you probably could have argued this case on behalf of the Second Amendment. You probably could have done that quite well, I'm guessing. Set aside the issues that arose involving en banc procedural rules, not important particularly for this video. Bottom line is, California made a lot of the arguments that we predicted they would make on this video, and there are clear answers to all of them. So let me just summarize where this case is. You may recall that Duncan versus Bonta has been up and down the chain of the Court of Appeals, the district courts, and so on for quite some time. And now they're hearing the case en banc. Now, when you hear en banc in a court of appeals, you have 3 judge panels, and then you have en banc panels. Now, in all courts of appeals, en banc means the entire court, every active judge in the Court of Appeals in like the 4th Circuit or the 2nd Circuit or the 3rd Circuit will sit and hear the case. But because the 9th Circuit Court of Appeals is so big and encompasses so many judges, so many states, they have what's known as a partial en banc, which means I think about 11 judges or so, or a third of the court will hear that case. And that's what happened today in Duncan versus Bonta. So that's what we had. There were some good Second Amendment judges on this panel, so there will likely be some dissents from the ultimately terrible decision against the Second Amendment. We covered some of these games involving the en banc rulings. If you may remember several months ago, I covered the fact that this case should not have been done en banc the way this was done, the way it was assigned. But again, the issue is going to be is that there is an ongoing delay, and we're going to cover some of this in one second, by anti-gun judges, including in the Ninth Circuit, to make sure that the U.S. Supreme Court never gets to hear an AR-15 ban case or a magazine ban case or any Second Amendment case. They're just trying to keep it down in the lower courts as long as they can, hoping that the Democrats will either be able to pack the Supreme Court and add a bunch of progressive judges like more Justice Brown Jacksons, or replace Justice Alito or Justice Thomas, 2 of the older justices on the court, with some progressive law professor somewhere that will always rule for the left-wing cause. Anyway, with that said, let's talk about some of the arguments made today. And let's begin first and foremost with the argument made by California in its opening statement right here.
The Supreme Court has recognized that not every type of weapon is protected by the Second Amendment, and that certain weapons, like M16s, may be banned. The statute challenged here restricts the capacity of magazines to 10 rounds without putting any limit on the number of lawful magazines or the amount of ammunition that gun owners may possess and use. That statute is constitutional at both stages of Bruin's framework. At the first stage, it's plaintiff's burden to show that large capacity magazines are presumptively protected under the original meaning of the Second Amendment. And that inquiry includes consideration of the objective character of the device and whether it's a self-defense weapon. The record here establishes that large capacity magazines are not self-defense weapons. These are especially dangerous devices that allow an attacker to maximize casualties with a huge volume of rapid and uninterrupted fire.
So that kind of tells you where California is coming from. But the good news is we had a strong lawyer, Erin Murphy, arguing in favor of the Second Amendment. Here was her opening statement in Duncan versus Bonta today.
Good morning, Your Honors, and may it please the Court, Erin Murphy, on behalf of the plaintiffs. Tens of millions of law-abiding citizens across the country keep and bear magazines capable of holding more than 10 rounds for lawful purposes like self-defense. Under the Supreme Court's decisions in Brewer and Heller, that forecloses California's effort to ban them because the court has been emphatic that our tradition is one of protecting the right to possess arms that are in common use today. The state's efforts to resist that conclusion are fundamentally incompatible with what Heller instructs and Bruin instructs are the definition of the term arms and the historical tradition about what kinds of arms the state may ban consistent with the Second Amendment.
Is your position that...
So that kind of lays out the battle lines. Now let's talk about some of the obvious arguments California made. We knew they were going to make this. They immediately jump into the notion that issues associated with magazines that hold more than 10 rounds are somehow unprecedented societal change or technological change, which is exactly what I had predicted before, so much so that I knew this was coming. I wrote the definitive argument rebutting this in the Harvard Journal of Law and Public Policy. We've covered this on this channel before. But again, when I talk to you on this channel, I'm speaking to you in the real world. I'm not just some airy-fairy kind of guy that talks about shall not be infringed and pretend that's the end of the game. I'm trying to tell you how we can win in a modern America, including in the courts, in the realities of where we are, because I'm not on the Supreme Court, so there's only so much I can do, but I'm trying to give you the best arguments, including telling you where the anti-gunners are coming. So here you had California doing exactly what I predicted, talking about unprecedented societal change being a justification for nuanced analysis, which is basically a euphemism for saying we're going to ignore the Supreme Court precedent and you, Ninth Circuit, get to make it up. Check out this argument by California right here.
Counsel, as I see it, I think common usage is in both Step 1 and Step 2 of Bruin. I agree with you that common usage should be taken into account of what is an arm, but do you agree that it also has a place in Step 2 where if a state proffers a historical analog that prohibits something that's dangerous or unusual, do we then say, well, if it might have been dangerous or unusual back then, but given that it's common use today, it's not a proper analog? That's what I think Bruin was telling us.
Well, Your Honor, I'm not sure that I would characterize it that way, but I will grant you that, especially in a case like this one, where we're dealing with a dramatic new technology and a problem that didn't exist in the relevant historical periods, that you have to have a nuanced understanding of the history. I think if you get to this stage 2, we have a long tradition before and after the founding of governments heavily restricting and sometimes banning especially dangerous weapons. And Bruin teaches that you need to take a nuanced view of that history in a case such as this one. I think that the type of restriction that we're dealing with today falls comfortably within that tradition, and certainly if you proceed to the other questions that Bruin says we have to ask, does it comparably burden the right to self-defense? Is it comparably justified? I think we satisfy those points. I mean, the First Circuit, I think, just addressed this recently, but when you have a law like ours that does not restrict how many magazines, lawful magazines, somebody can carry. It does not restrict the amount of ammunition they can use and possess or how many shots they can fire. It just limits the capacity of a particular magazine. I think that in comparative terms, the burden on the right to self-defense is much less than some of the historical analogs where governments looked at particularly dangerous weapons and banned their possession altogether.
Now, beyond that, of course, California does another mistake. No shock here. They want to elevate, and we've talked about this before, they want to elevate every single conceivable problem or fight or issue associated with Second Amendment cases to what? They want to elevate it to the plain text analysis. As a reminder, both Heller and Bruin had the same methodology of interpreting the Second Amendment. You start with the plain text of the Second Amendment, and once the modern-day gun control law is implicated by the plain text of the Second Amendment, the burden shifts to the government to come forth with historical examples going back to the founding to justify the modern-day gun control law. So you understand what I just said? At the textual level, the burden is on really the Second Amendment plaintiffs to argue that the modern-day gun control law is implicated by the text. But once you satisfy the text, the burden shifts to the government to do the historical work. So the government is desperate to avoid having the burden shifted to them at the historical level. So here is California arguing that the burden on the in common use test, which, as you know from prior videos, the in common use test arises from American history, both the notion that Americans brought commonly owned firearms with them, the militia musters, and there's a concept in common law that you can ban the carrying of dangerous and unusual weapons based on all of that gestalt or that sort of combination of things. The Supreme Court said in Heller that when you're dealing with an arms ban case, such as Duncan, which is a magazine ban case, which is an arm, because it's a necessary component of a modern-day firearm, if you're dealing with an arms ban case, Heller teaches that you apply the in common use test, because the in common use test says that if it's in common use by Americans for lawful purposes, it cannot be banned based on those historical traditions. But you see what I just said? That's all part of the historical tradition. And who bears the burden? When you're talking about history, we know who bears the burden. It's the government. But here's an example of California trying to argue that the in common use test is actually part of the textual analysis, and thus it's the burden of the Second Amendment parties to argue that these guns are in common use for self-defense and so on, and not the government's burden to show they're not in common use. Check this argument out by California right here.
Why isn't the first step a simple textual step, and the question for us whether a magazine or a large capacity magazine is an arm at all, or whether it's an accessory or something else?
Sure, Your Honor. I do think that that's part of the first step, but it's not the only part of the first step.
Why don't the other issues belong in the second step?
So, two answers to that, Your Honor: precedent and history. So as a matter of precedent, I think Bruin is quite clear on this. At page 32 of that opinion, it says you have to look at, is this device in common use today for self-defense, before it held at page 33 of the opinion that the plaintiff's proposed conduct was presumptively protected. This circuit's precedent said the same thing, and I believe that the dissenting judges on this panel at the stay stage recognized that common use for self-defense and the dangerous and unusual tradition go at the first stage because they bear on the original meaning of the Second Amendment.
And of course, by extension, California, like all the anti-gun lawyers, the anti-gun lobbyists, all the anti-gunners out there, the scholars, all want to then argue that the test is not that Americans possess an arm for all lawful purposes. They want to narrow it down for self-defense. They want to say that it's in common use for self-defense. And then what they do is they do a sleight of hand and say that these are commonly used for self-defense because people either use AR-15s every day all the time by pulling the trigger for self-defense, or they empty magazines that hold more than 10 rounds. And because, of course, being able or using a gun in self-defense in terms of pulling the trigger is a very rare event, the anti-gunners have figured out that by saying that the burden of proof is on the Second Amendment community to show that guns are fired every day in self-defense is common use, blah, blah, blah. And that's not really possible to do in a real sense. The way they define, I mean, you have to actually shoot the gun or empty the mag with more than 10 rounds. Those are obviously rare events in the grand scheme of things, and thank God they are, because the whole Second Amendment really is about rare events. If you think about it, protecting yourself against all forms of tyranny, most of us go through lives without actually having to pull a trigger and shoot anyone, which is great. But of course, the anti-gunners are trying to use that against us. And here is how California, again, is trying to argue that the in common use test is not in common use for all lawful purposes, but instead it's limited to in common use for self-defense. Roll the tape here.
With the common use notion, I mean, whether it's in the front end or the back end, is your essential answer is that it cannot drive the conclusion, or what exactly?
Right. So I think that
there are lots of these things. Okay.
Yes.
So but it seems like they are in common use. Maybe they're not in common use for self-defense. That's one possibility. But what else?
We think that numbers alone are not sufficient, Your Honor.
Again, once California is able to kind of make that argument about self-defense and put the burden on the Second Amendment, put the burden of proof on the Second Amendment plaintiffs, and then say that self-defense or using for self-defense equals pulling the trigger, you can see why they would make it very hard for Second Amendment proponents to be able to win these cases. But of course, that's entirely inconsistent with the fact that we have the text of the Second Amendment itself. The right of the people to keep and bear arms shall not be infringed is the law. That is the presumption. Everything other than is at most an exception to that, and that is why the burden is on the government to show that an exception to that text is appropriate in those rare instances where there's some longstanding historical rule. And the example, again, I like to give is the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. But that has never been understood to give you and I the right to use a gun to commit cold-blooded murder. Even though that exception is not in the text of the Second Amendment, is understood historically, going all the way back to the founding founding that no one is allowed to use arms to commit cold-blooded murder. That's just part of the historical legal tradition that everyone, including the founders, thought was acceptable. That's the sort of example, a historical example that the anti-gunners have to come up with, and they bear the burden to do so. And they hate that because the reality is there's very few gun control-related laws at the time of the founding, and the anti-gun movement should lose virtually every case. But of course, they don't want to do that. And the judges on the bench that don't want you to have guns because they think you're a peon, you're not smart and elite like them, and you don't deserve the same protections they get. Well, let's say if you're a federal judge protected by the U.S. Marshal Service, the reality is they don't think you're as good as they are, and you don't deserve the protections that they get. That's just the reality of it. But we understand this. But the good news is we're out there fighting the good fight in support of the Constitution, and this game is not over. But let's carry on. Now, the next thing came up involves, and this is funny. It's not funny. It's actually kind of sad. We talked about this like a year ago, that California's brief talked about how there's 700, and follow me carefully here. This is very important that you understand this nuance. Very important. California's brief said that there were 700,000 machine guns registered in the United States, and then they basically said that that means there's 700,000 machine guns in civilian hands. Okay? Then they argue, and you're going to see how they do it today with this colloquy with the judges. Then they basically say that the in common use test cannot just be a numerosity or a numerical threshold where you get over a certain number and an arm is protected, period, full stop. And what they argue, and listen carefully how they do it, they say that because there's 700,000 machine guns in the United States in civilian hands, and because the Supreme Court in Heller said that machine guns, i.e. M16s and the like, which is the language from Heller, can be banned, they said it cannot possibly be the case that 700,000 or that the numerical number is enough to constitute in common use and thus prevent a ban. Because they said there are 700,000 machine guns in America, yet the Supreme Court has said they can be banned. Now, here's the key, and I don't think this was made clear during the oral argument. There are not 700,000 machine guns in civilian hands in America today. That is the number of machine guns that is registered under the NFA is 700,000. And I'll put the links to these down below. We've talked about this in prior videos before. In 1986, when the Hughes Amendment was adopted and you can no longer buy new machine guns if you're just an ordinary citizen, the number of machine guns in circulation at that time was around 160,000 or so. Okay? The reason why, and the rest, by the way, that are registered machine guns are registered either by local or state law enforcement who have a duty to register under the NFA, or is registered by gun companies that perhaps are working on machine gun projects for the government or whatever it is. Okay, so the 700,000 figure of machine guns registered under the NFA includes the 160 some odd thousand guns that were around and owned and possessed by civilians as of 1986 when the Hughes Amendment was enacted. The rest are either state, local, law enforcement, or gun companies. But this was not made clear to the court. The reason why this is so important, a very important piece of evidence, as you know, in the context of fighting over arms ban, is the 2016 Supreme Court case of Caetano versus Massachusetts, where the concurrence of Justice Alito discusses how the dangerous and unusual test is conjunctive. That gives rise to the in common use test, meaning if Americans are in commonly own a particular arm for lawful purposes, it's protected. And then he talks about how there are 200,000 Americans own stun guns. So the 200,000 threshold really is the cutoff between what's protected under the in common use test and perhaps what's not. Now, the reason why it's important that the 200,000 figure in the stun gun context of Caetano is that number for a lower level base threshold of what's protected under the in common use test is because the Supreme Court in Heller did say machine guns are not protected. M16s are not protected arms. If the number of civilian arms is 160,000, that is below that 200,000 threshold with stun guns. Okay, but if 700,000 is the machine gun number, which is what the anti-gunners are trying to get by the court, then it doesn't make sense, that 200,000 number, because the machine guns would be protected under the in common use test, but the Supreme Court has already said they're not protected. And they're never, and here's where I'm not going to, this is not a rainbow and unicorns channel, okay? There are other channels out there that will tell you all sorts of news to get clicks and get views. I don't do that. I'm telling you what I think is the reality on the ground. And the reality on the ground today is there are not 5 votes. There are simply not 5 votes on the current Supreme Court to find that machine guns are protected arms under the Second Amendment. So for the moment, there is no way we're going to be able to get machine guns protected under the Second Amendment as a protected arm right here, right now. Maybe that will change down the road, but for now, we're not going to be able to get there. So that's why it's very important that we make it clear in these AR-15 and magazine ban cases that the 200,000 threshold of stun guns in Caetano is the right threshold, because it justifies how they can ban machine guns at the 160,000 mark, which is what is in civilian hands. And then, of course, the reason why this is important, there's no doubt that the magazines that hold more than 10 rounds, or AR-15s, are hugely more than 200,000. There are tens of millions of these out there, maybe even hundreds of millions when it comes to magazines. But it's very important that the in-common use test be protected if we want to preserve AR-15s and magazines that hold more than 10 rounds. And that's why this difference between the 160,000 machine guns in civilian hands versus the 200,000 stun guns talked about in Caetano, and of course, that 700,000 figure, which the anti-gunners are trying to use against us by conflating civilian numbers with law enforcement numbers with gun company numbers, that distinction that I just made was not made clear during the oral argument on Duncan versus Bonta. And if I could make one change to the argument, this is the thing that I thought needed to be rebutted clearly, because otherwise the anti-gunners are going to try to use this as an excuse to ignore the in-common use test, to say that can't be a pure numbers test, because if it were, then the Supreme Court statement that they can ban M16s would not make sense. So I have a feeling that if this ruling goes against us, which it will, that will make a prominent appearance in the opinion, but we'll see what happens. So anyway, with that said, let's just look at the Second Amendment attorney Aaron Murphy's discussion of machine guns here in the argument in light of what I just said. Check it out here.
A friend's argument that there's, I think, 700,000 machine gun licenses out there in the world right now. That seems like a pretty big number.
It's a decently big number. I mean, obviously it's bigger than the number Justice Alito talked about in Caetano. We don't have any real analysis of the manner of the kind of typical use question there. How many of them are really owned more as kind of a novelty or something that can only be used under very, very strict circumstances at particular places, as opposed to actually being kept and used by people for self-defense. Nobody's tried to make a record on that.
So, counsel, it sounds like you're agreeing that.
Okay, the last point I want to make is simply there's a discussion about whether or not this court should do something that it's never done before, which is to have a full en banc hearing of all the members of the Ninth Circuit. We absolutely do not want this. This is another game by the anti-gun judges in the Ninth Circuit to have yet another excuse to delay things, because remember, the goal of the anti-gun judges is to prevent a ruling on the merits of the Second Amendment, so the Supreme Court never, ever has an opportunity to hear a case, because there's never a final decision on the Second Amendment on the merits in these gun ban cases, and they don't want that again until the current composition of the Supreme Court changes. So we do not want the full en banc hearing by the Ninth Circuit. That will be nothing more than a delay tactic and prevent us from getting the U.S. Supreme Court, where if we can get one of these cases, either the magazine case or the AR-15 case, to the United States Supreme Court, I believe almost certainly we will prevail on the merits. But we have to get those cases to the Supreme Court, and right now we're not there, but hopefully we will be there very soon. But anyway, here is the reference to en banc. I just want you to see where the anti-gun judges are thinking, how their brain is working right here and right now.
What is your view on whether this should be, due to its importance and to your concerns about whether we ought to hear it as a limited en banc, whether this should be a full court decision?
I mean, I certainly enjoy participating in the first ever full en banc sitting, but I don't know why the court has to go to that step.
I didn't say we had to. I'm asking your view as to whether it's a good idea.
It seems to me the logical course would be to start with the ordinary procedures of take a full court vote.
That sounds a lot like judge shopping. If you had a full court en banc, you would get, by definition, the real view of this entire court about this question. Why isn't that a good idea?
I mean, it's perfectly fine, and it's the prerogative of this court. I've just happened, as a historical matter, the court has never done that and gone straight to that. And so I would think in the ordinary course, I wouldn't consider it judge shopping. I would just consider it following this court's ordinary procedures to start with the 11-judge panel.
If we were to have another vote of the active judges and they voted to take it on Banc, would this be the panel or would it be a different panel?
No, I think you'd have to have a new panel.
Why is that?
For one, I think that the voting contemplates that then you have a new panel, but I do think that independent of the issue about the vote, the final clause of the second sentence of the statute precludes the active judge, the senior judges, from participating in the hearing, because the senior judges can only participate in the decision if they were active when the case was heard.
Of a case or controversy. There hasn't been a decision of the case or controversy.
All right, folks, hope you learned something here today. I suspect we're not going to get a decision in Duncan versus Bonta until the end of the year. They're going to slow walk this 6 ways to Sunday. That's my guess. And there's even references that they're not even going to contemplate this case until after the Rahimi case is decided, which is utterly stupid, because Rahimi deals with something having nothing to do with an arms ban case. You already have the Heller arms ban ruling, the constitutional test. That's all they need to apply. But these anti-gun judges are simply not going to apply the law. They're looking for excuses to take away your rights and to allow the government of California to take away your rights. That's the harsh reality of it. And you go, again, I'm not here for rainbows and unicorns. I don't just tell you things you want to hear. I tell you things the way I think they really are in the real world, because only by diagnosing the problem accurately can we move forward and get to where we ultimately want to be, which is protecting our rights fully under the Second Amendment and making it a first-class right, just like everything else in the Constitution. So anyway, there you have it. Hope you learned something here today. Make sure you subscribe and check your subscription every time you like this video. People keep getting knocked off the subscription list. I don't know why. We're trying to get to 150,000 subscribers here. And don't forget to follow me on X at 4 Boxes Diner. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.